All rise. Court is now in session. You may be seated.
Madam Reports number 5 on today's list is indictment 14-393, Commonwealth versus Erika Murray. Counsel will just identify themselves for the record.
Good afternoon, Your Honor. Christopher Hydrens for the Commonwealth.
Good afternoon, Your Honor. Keith Halpern for Ms. Murray.
All right, let's have Ms. Murray sit at the table, please.
Thank you.
All right, good afternoon, everybody. So what I have received since we last met is the defendant's motion for reconsideration, renewed motion for directed verdict and to vacate convictions. I've also received a supplemental memo, similarly. I've also received the Commonwealth's opposition to that. I have read all of it. I have also received the sentencing memorandum that the defendant has filed, and I've also received the sentencing memorandum from the Commonwealth. I've read all of that. So I want to hear first on the motion of the defense before we do sentencing.
Thank you, Your Honor. I think the crux of the motion is the question of what it means for something to be a lesser included offense. There are two cases which clearly hold, one SJC case and one appeals court case, that reckless endangerment is a lesser included of the fourth section of the assault and battery on a child statute that deals with wanton and reckless conduct, which is the portion of the statute at issue in this case. For a lesser included to exist, the crime necessarily has to be accomplished upon the commission of the greater offense. So the assault and battery charge cannot have a more liberal or forgiving state of mind requirement than the standard that applies to the reckless endangerment statute. But that's exactly what the court did, and it may well have been based on model jury instructions, which are in fact wrong with respect to only this one paragraph that deals with reckless, wanton, and reckless behavior. If reckless endangerment has a subjective element, which it clearly does, it's defined in the statute, that the Commonwealth has to prove, then it is harder for the Commonwealth to prove that crime than it would be to prove assault and battery if assault and battery could be satisfied by merely a reasonable person standard. And that makes it impossible for reckless endangerment to be a lesser included. That, I think, is the most compelling argument. There are others. The fact that, the court referenced, as has the Commonwealth, a number of manslaughter cases, which I don't think apply because there is no reference in the manslaughter statute to wanton and reckless conduct. The application of wanton and reckless behavior to constitute the basis of a manslaughter is based entirely on common law. There's nothing in the statute that references it. It's a creation of common law. That's different than the assault and battery statute, which does reference wanton and reckless behavior. It simply doesn't provide a definition of it. And I've provided the court with a number of cases, both state and federal, which talk about the importance of consistency in definitions when the same word is used by the legislature in similar contexts. And here, there actually was a Latin term for this, which I learned, peri materia, which deals with whether or not the statutes are similar, whether they involve, whether their purpose is to protect the same class of individuals, whether the targets are similar. And here, I think they clearly are, both in terms of the potential victims that are being protected and the potential targets for prosecution. And in that context, the SJC says that there is an important purpose to be served by the court applying the same definition to the same words when the legislature uses the same words in statutes that are similar in that fashion. And coincidentally, on the day that I wrote this, or the day before, the United States Supreme Court came out with a decision in a sentencing case, United States v. Davis, which essentially says the same thing. In all but the most unusual situations, a single use of a statutory phrase must have a fixed meaning. And though this goes back to why the manslaughter cases are not of import here, because there is no reference in the manslaughter cases, in the manslaughter statute, to the phrase wanton and reckless. The Supreme Court continued, we presume the same language in related statutes carries a consistent meaning. And that's I think, the crux of it, that the Commonwealth concedes that reckless endangerment is a lesser included of this offense. If it is, then the state of mind requirement has to be the same.
Thank you. Commonwealth.
Your Honor, Commonwealth would essentially submit on the written opposition. The Rodriguez case, I believe, addresses the issue of lesser included and actually indicates, although not the precise issue that's raised here, but does indicate in that case that a lesser included offense does not, as people often assume, have to have the same elements. And in fact, in this case, it doesn't. There is an alternative element available in the reckless injury to a child statute that doesn't exist in the reckless endangerment statute. And I believe this court made it very clear in the findings that were made that you were drawing upon the distinction between these two statutes and that you recognized it clearly. And in fact, the evidence in the case showed that we were dealing with two different sets of victims entirely, and two different sets of facts that applied to each set of victims. And in fact, the reckless endangerment statute involved a potential risk of harm to the children, which is a very different type of harm than a manifest physical injury to the youngest children in the reckless injury indictments. So given all of that, I would ask that the motion for reconsideration be denied.
Okay, thank you. First of all, 265.13J(B) consists of 4 paragraphs. Each paragraph is if you will, a separate offense. In the Rodriguez case, the defendant in that case was charged under paragraph 4, but specifically permitting an assault and battery. And the issue that the SJC was determining in that case was whether or not the judge had made a mistake at the request of the defense attorney in charging the jury on a lesser included, and determined that the judge did make a mistake and should not have charged the jury on the lesser included offense, as the SJC found it, on reckless endangerment. For that set of facts, they were not addressing the question of the intent issue, because the only issue in there was wanton and recklessly permitting another to commit an assault and battery that resulted in substantial bodily injury. And the facts of that case were, there was only, on any reading of the facts, it didn't support a lesser included offense, because on that case, either the defendant was awake and therefore aware, which is that conscious awareness, or if she was asleep or it was an accident, then she couldn't have been aware. And that's awareness is either under a subjective or objective standard. It really didn't matter given the facts of that case. So I think that Rodriguez is distinguishable. Also, what needs to be said again is I did not make a finding that, as the Commonwealth has pointed out in its opposition, under the charges of reckless endangerment here, that had to do with Kayla and Nicholas, based on the conditions in the home. The issues that was here had to do on the A and B, on the children, meaning Mackenzie and Madison. That was not based necessarily on the conditions in the home. And it was not the same victims. And one of the issues that I had said in my findings was that because of her conscious awareness of, because that was absolutely required under 13L, there is no objective standard at all available under 13L, that given her mental condition, that as to Kayla and Nicholas, she was not consciously aware as defined under the statute due to her mental impairment. That is not necessarily the case with Mackenzie and Madison. Under either standard, whether it be objective or subjective, under 13J, and I still contend that it can be either one. I did not make a finding that her mental impairment prevented her from being consciously aware, if that is what is required, because it's different. It doesn't have to necessarily be conscious awareness as defined under 13L to be the subjective standard under 13J. I also have read some other cases on this, and while some of these cases are very interesting, they also point out, and one of them is Chapman, which is, granted, was decided before the Rodriguez case. In that case, where there was a question about whether the instructions to the jury were incorrect by the judge on wanton and reckless conduct under 13J, B, paragraph 4, the SJC found that is not, that it was the Wolanski definition of wanton and reckless conduct, and that the judge's instructions were proper, that it could be either the subjective or objective standard was sufficient. So while that's not directly on point, it reiterates for me that the standard could be the same. So for those reasons, I am denying the defendant's motion to vacate. My verdict stands on counts 3 and 4. Exceptions are saved for the record. That brings us to sentencing. Does the Commonwealth move for sentencing?
Yes, Your Honor.
You wish to be heard?
Very briefly, Your Honor.
All righty.
The Commonwealth has filed a sentencing memorandum, which I think outlines the Commonwealth's principal positions. I would just add a couple of thoughts. Since the end of the trial and the court's decision, I tried to put the case out of my mind, but two aspects of it continue to sort of haunt. And one of those is the children, the youngest children. They were in a very vulnerable position. I'd suggest that's an aggravating factor here. And they were vulnerable not just because of their age, but because of the circumstances that they were in. They were very young. They did not have a great deal of contact with the outside world, so to speak. They were very dependent on the defendant in this case. They couldn't speak when they were hurt, or they couldn't summon help, let someone know that they were in peril. The other aggravating factor here is related to that, and that is the relationship of the defendant to these children. The defendant was not a passerby. The defendant was not a bystander. The defendant stood in a very significant position. She was a parent. And as much as being a parent is a blessing, it also carries with it great responsibilities. And my first thought was to say to the court that the defendant was derelict in her duties as a parent. But I think even dereliction doesn't really approach describing the conduct. I would suggest it was more of an abdication, a complete abdication of her role as a parent. So those two aggravating factors, in addition to the factors outlined in the Commonwealth's memorandum, I would suggest merit punishment in this case. And that's a word that we don't often say in court, but it is a word the Supreme Judicial Court references as appropriate in sentencing. It's not just taking someone out of society for the protection of society, but there is a measure of punishment as well to vindicate those principles, such as the role of the parent, such as the vulnerability of the children in this case. So the Commonwealth is recommending a period of incarceration based upon that. 4 years, 4 to 4.5 years, followed by 2.5 years in the House of Correction, and another 2.5 years on and after. Commonwealth is also recommending a period of probation of 5 years. And the purpose of that recommendation, Your Honor, there's a couple of reasons for that. The first is the overriding goal in this case, and in many cases, from the district attorney's point of view, is the prevention of crime. And the chief concern going forward from the district attorney's point of view is the assurance, or is assuring as much as we can, that this sort of thing won't happen in the future. And that probation with special conditions, including no unsupervised contact with children under the age of 10, would help to not guarantee, but at least move towards prevention of this issue in the future, as well as cooperation with DCF with any plan that they put forward. And then the other aspect of probation is, again, a major aspect of this case, as the court had found, and that is to address the mental health issues that have been unaddressed, largely unaddressed throughout this case. So it's hoped that with some mandated mental health counseling, evaluation, and treatment going forward, that the defendant can get the help that she needs, so again, that no one is ever put in a position like this again. So for all of those reasons, Commonwealth asks that the court consider the recommendation.
All right, thank you very much.
Thank you.
Defense.
It's difficult for me to imagine any case in which there would be less risk of recidivism of some similar offense, or any offense, than this one. The circumstances of this case are wholly unique, and it's really difficult to even conceptualize what it is that the district attorney's office would be concerned about happening again. The convictions, all of the convictions, are based upon the fact that her state of mind was not subjective state of mind was not a relevant concern to these counts. I agree that with respect to the assault and battery counts, there could be alternative ways in which she could have perceived harm or risk. So, for example, noticing that Mackenzie had difficulty walking or that her feet were bent. If she had the capacity to realize that that was abnormal, that would be an alternative awareness in contrast to the condition of the house. I don't think the same could be said for Madison. I think the injuries that were described of Madison at the trial were far more subtle, difficult, I think, for most parents to have recognized. But the mental illness issue, I think, is critical, because if it's not being considered with respect to liability based on the standards that are applying, it has to be considered with respect to sentencing. And it takes this case completely out of the norm in terms of what these crimes typically involve. The animal cruelty counts really are a kind of collateral damage. I would suspect that in virtually all animal cruelty cases, the animals are deliberately targeted in some way. They are victimized, and it happens knowingly. In this case, the harm was caused by the conditions of the house, not by a willful intent to harm the animals. And I think that takes this case way out of the norm in terms of comparing the conduct here to a typical case. The guideline range is 0 to 12 months, and I think based on the issue of mental illness and the lack of subjective awareness, it's appropriate that she be sentenced at the very low end of that, and I'd suggest probation. Turning to the significant counts, if mental illness isn't being considered as a basis for acquittal, it has to be considered in a very profound way in terms of culpability and what an appropriate sentence here is. And I would agree with virtually everything Mr. Hodgins had to say about punishment being deserved if the evidence established willfulness. If the evidence had established that she intended to cause harm to these children and was aware of what she was doing and did it on purpose. But there's no evidence of that. And the fact that the conviction is based on a reasonable person standard, and that I think was a critical component of the basis of the conviction, is critical in terms of distinguishing this case from the norm. Because as with the animal cruelty counts, I suspect that close to all cases that come to court involving assault and battery on a child involve some subjective awareness that goes far beyond what we have in this case. The guideline is 1 to 3 years. She's already been in close to 5. That guideline would typically, I think, apply, the midpoint would typically apply to a typical defendant in a typical case. This isn't a typical case. And if you assume, as I think it's fair to assume, that the vast majority of defendants charged with this offense do have some degree of intent. They knew what they were doing, they knew they were harming children, and they did it on purpose. She doesn't deserve to be treated in the same fashion as somebody who acts with that sort of deliberate intent. So, I view this case as warranting a sentence at the low end of the guideline range, particularly because of the issue of mental illness and the lack of intent. Whether that is 1 year or 1.5, but I feel that it's justified that it be below the midpoint because of the issue of mental illness and the lack of intent. There are other factors that I think weigh in favor of a lower sentence here that are unique because of how long this case has been pending. You typically do not have a defendant coming to court with the history that she has been able to provide the court, showing what she's been able to do during the past 5 years. There's been tremendous improvement in her mental state. I think a great deal of that stems from being removed from the house and being removed from Mr. Rivera. She has actively participated in every program and educational opportunity and training opportunity that the jail has allowed her to have access to. And she has a stellar record there, both in terms of participation in classes and in work, and got herself to a point where, in contrast to the beginning of her incarceration, where she was isolated, completely, for her own protection, she earned the respect and, I think, sympathy and compassion from the people who were there. She has worked hard to improve herself over the past 5 years, and I think that needs to be recognized too. Thank you.
Thank you. There's a lot of things that we do as judges that are difficult, but there is nothing more difficult than sentencing. We try to do it professionally, diligently. We try to take into account everything about the defendant that we know and can learn about, as well as what the society expects from us. And as I said, it's extremely difficult. There is nothing about this case that is normal. There is nothing about this case that is a rational, sensible set of events. So when I sit and I think long and hard about what sentence is appropriate given the crimes that she has been convicted of, I have to take into account that the normal does not necessarily apply. Much of what both of you have said, both orally today and in the sentencing memorandums, is absolutely true. A sentence by a judge, we have a significant amount of discretion and latitude, considerable latitude in determining what an appropriate individualized sentence should be. And when I say individualized, it's exactly that. A sentence has to reflect, among other things, several goals: punishment, deterrence, protection of the public, and rehabilitation. There are many factors that go into the decision, including hearsay information about her character, her behavior, her background, the nature of the offense, the circumstances surrounding the commission of that crime. I cannot take into account or undertake to punish her for conduct other than that for which she stands convicted. So I cannot punish her, as some might want me to, for the fact that the remains of 3 babies were found in the closets. That she's not convicted of anything to do with that, and I cannot punish her for that. So in considering this, I have taken into consideration, first of all, the guidelines which I found somewhat inappropriate in this case. And specifically, in looking at the guidelines under 265.13J, are rather confusing statute, and it's just as confusing in the guidelines. I found there to be an anomaly in the guidelines. If you look at what the guidelines suggest, they suggest that that should be a level 7 offense. Well, that makes no sense to me. I think that might apply for paragraph 2, which has a 15-year maximum sentence, but it does not make any sense for paragraphs 1, 3, and 4. And so I did not consider this to be a level 7 offense for the purposes of the guidelines. Much more appropriate is somewhere for a level 4, a level 5, perhaps a level 6. But I was somewhere in the level 5s when I considered that. I have taken into account the nature and circumstances of the offense. And I say the nature and circumstances, I mean the total circumstances of this case. I have taken into serious consideration, and it's weighed heavily on my mind, her mental state at the time that the offense occurred. I've also considered the relationship between Ms. Murray and the fact that these were her kids. I've also taken into consideration the nature and the degree of the physical and perhaps the mental harm, I don't know much about that was caused by her actions. Clearly the vulnerability of the victims in this case, well, they were children. They were the most vulnerable and had no way to defend or protect themselves. I have taken into consideration the community view of the gravity of the offense, the public concern that's been generated by the offense. I've also considered whether or not there's a deterrence effect by any particular sentence that I may have. I don't think so. Whatever sentence I give, I don't think is necessarily going to act as a deterrence to somebody under these set of conditions, because I don't know that there are any such set of conditions like these. I'm sure there might be, but I don't know of any. So I've tried to fashion a sentence that takes into consideration all of that, and also, I also have taken into consideration is, it's no question, no matter what sentence I impose, that Ms. Murray is going to have to join our society again. And what conditions do I impose, or do I impose that, number one, meet the criteria of sentencing that I need to meet, and also are helpful to her and help her to integrate back into our community and live a life that she has to live with all, and make it so that she succeeds at that. I think I have come up with something that I'm hoping will work, but that's of course up to her. All right, Mr. Lefebvre.
Ms. Murray, would you please stand? In consideration of the offenses to which you stand convicted on indictment 14-1393, count 3, the court orders you be punished by confinement to the Mass Correctional Institute at Cedar Junction for not more than 5 years, not less than 4 years. With respect to count 7, court orders you be punished by confinement to the Mass Correctional Institute at Cedar Junction for not more than 3 years, not less than 2 years, to run on and after your release from count 3. You'll be given credit in the amount of 1,765 days, and you're notified of your right to appeal that portion of this sentence to the appellate division of this court within 10 days of its imposition. With respects to counts 4 and 8, the court orders you be placed on probation for a term of 5 years to run from and after your release from sentence and concurrent with each other. Special conditions are mental health treatment as determined by the probation department, comply with any DCF service plans, comply with any probate and family court orders, sign any and all releases for the probation department, and no unsupervised contact with any children under the age of 10. Victim witness fee, DNA fee, and any unpaid legal fees in this matter are waived. There will be a $65 per month probation supervision fee. During the term of your probation, do you recognize with the probation department and you with the defendant?
Yes.
Mr. Court Officer, Ms. Murray is in your custody under sentence.
Let me also say that I am ordering that, written onto the minimus, that I am strongly recommending that Ms. Murray serve her sentence at the Chicopee Women's Facility as opposed to a state prison sentence. And that will be on the minimus. And I'm also, can I see counsel at sidebar? Ms. Murray can sit there for a minute. All right. All right. All right. And all fees are waived,
Thank you.
exception of the probation supervision fees. All right. Good luck, man.